Well, good morning, everyone, and welcome to today's webinar. This is Jeff Bregelman at the Gislason office of Gislason and Hunter, the New Ulm office. With me is Mike Dove and Dean Zimmerly, and we'll be hosting today's webinar, Springtime Stressors for Ag Lenders. A few housekeeping things before we get going. The webinar is being recorded. So there'll be an audio recording available via our website. The slides that we viewed today will be available there as well. We'll have them posted for about a month or so after today's webinar. So feel free to refer back to those or refer your colleagues to the website if you hopefully find that this is informative and beneficial to you. I understand you have the means to submit questions today via the webinar connection, and we invite you to do that. Given the amount of materials we plan to cover, I can't promise that we will field all the questions during the course of the webinar today, but we will take all of them, answer at least some, and we can certainly follow up later if we don't get to your question today, or feel free to follow up with your own phone call or email to any one of us with any follow-up questions you might have. Your end is muted, so we can't hear questions that, or comments you might make. So if you do have any comments or questions, please submit them via the link. If you have any kind of technical problems today, just call our main number here in New Ulm, 507-354-3111, 507-354-3111, and ask for help in getting reconnected if that's what you need, or if you have other technical difficulties or questions. All right. We picked this topic because we recognize that springtime can be a challenging period for ag lenders. We've heard from some of our clients that renewal season has maybe been a little rough this year, rougher than the past. You undoubtedly have maybe even long-standing borrowers who are looking to finance this year's inputs, but you may be facing some challenges that you haven't in recent years. There may be some residuals from poor 2016 performance, and projections for 2017 may not be looking quite as optimistic as you would hope. So what we hope to talk about today are some particular issues or challenges you might face in that context, and as you think about decisions you need to make for the upcoming crop year and financing or potential financing for crop inputs. Today's discussion is going to be focused on crop financing. We're not going to talk about issues that might arise related to equipment financing or livestock financing. We're going to try to keep it pretty narrowly focused to crop input financing. We thought a threshold issue to put out there is the question, can you decline to extend new financing for this year? Kind of the premise we came from is that it's renewal season, and you're probably having to decide whether and how to renew a lending relationship that you may have had for some time. But it's good at the outset to ask, well, what do your loan documents provide, and are you, in fact, in any way already obligated to provide crop input financing for this year? Just because you have in the past, that does not obligate you to do it this year. The answer to this question is going to be driven by your loan documents. If in the past you have had fixed-term loans or lines of credit with fixed end dates, or lines of credit where it's absolutely discretionary on your part whether you make advances for these sorts of inputs, then you're not obligated to do it again for this year. Hold on a second. But there can be situations where loan documents have committed the lender to continue a previously extended line of credit or a commitment that they've made. Keep in mind the statute of frauds that you often hear us talk about at our seminars, 513.33, which basically says that these sorts of agreements to lend have to be in writing to be enforceable, and oral commitments to lend typically, generally, are not enforceable. But what about, email exchanges, letters that you might have sent to the borrower, notes that you've exchanged with the borrower? Sometimes those can be the source of questions or potential arguments that a bank has maybe committed itself in some fashion to extend this sort of credit and these sort of credit facilities, even unknowingly. So we just wanted to get that reminder out there. Just be cognizant of what your loan documents provide, and if you have any question as to whether any sort of statement you might have made or correspondence you might have had with the borrower could potentially commit you in some fashion, just watch out for that and seek counsel if you have any particular concerns or questions about that. Next slide, input financing elsewhere. We summarize this because this kind of seems to be a typical concern that lenders have, particularly if at this time of the year they are considering not extending or maybe not extending as much credit for the coming year's operations. Where else might this borrower go to get financing if you don't provide it? And what sort of impact might that have on your situation and on your relationship with your borrower? So a few examples here. Obviously, they might just go to another financial institution and seek financing there. They might find a supplier who's willing to sell them seed and other inputs on credit, on open account. That can raise some issues and tensions between that supplier and the prior lender. They might convince their landlord to defer rent payments till later in the year. What does that do then? If they start farming in 2017, they haven't paid any rent by agreement, but then it goes unpaid at the end of the year or whenever it's due. And you might have situations where borrowers decide, I guess with or without your knowledge and consent, to liquidate other existing assets and use those proceeds to fund their operations. So we're going to talk through some of those scenarios. We come at this basically, with this premise. We're going to assume that that you are an existing lender. You've had a relationship with this borrower for some time, so you already have in place some amount of loans, some credit that's already been extended, and you have in place a security interest that covers crops. And all crops, existing crops, crops that are growing, to be grown, future crops, and so forth. And we assume for purposes of this discussion that you have priority as to crops. So you've perfected that security interest in the past, it extends to crops, and now 2017 crop year is on the horizon with your prior perfected security interest in place. All right, what can happen if your borrower goes somewhere else to get input financing? As is often the case, a good place to start is with your loan documents. Is there any language that prohibits that? And if so, what sort of remedies or recourse might you have? It is the general rule that unless your loan documents prohibit it, there's no obligation that the borrower pay you off first. There's no prohibition on going somewhere else to get credit or to grant liens or security interests voluntarily or involuntarily to the other parties who might provide some financing. Now, if they do go somewhere else to a third party for financing, obviously if they don't pay you off, your debt remains outstanding, and the liens that you have that secure that debt remain in place. But one of the things we'll be talking about today is how that situation can be potentially disrupted. If your borrower goes elsewhere, your security interests and mortgages will continue in the same collateral. If you've got a financing statement filed and you're in first place, you're going to remain in a prior lien position. Any standard security agreement you take or security interest you perfect is going to attach to after acquired property. So if you put it in place in 2016, it's going to attach to 2017 crops. And we begin with the general rule that if you were the first to file, your priority is first. But of course, we'll be going on to talk about ways in which that might be changed or disrupted. On that note, sometimes you hear lenders say, well, but I financed this guy's 2016 or 2017 operation. Doesn't that give me priority? No, it doesn't. The mere fact that a lender has loaned money for inputs does not, automatically give any sort of priority over previously perfected security interests. What are some ways to deal with this situation if you're on the reverse side of it? Suppose someone has approached you and says, I'd like you to provide financing. I've already got an existing lending relationship with someone else, but I want to do at least maybe some limited lending or borrowing with you and offer my 2017 crop and operations as collateral. What are some ways to deal with this? Well, one, maybe look for unencumbered assets that would let you secure this year's operations without getting into these sort of priority conflicts. If you are going to provide a line of credit that's going to pay off some prior lender, then obviously make sure that lender in fact gets paid off by controlling how your loan proceeds are dispersed and by obtaining the necessary satisfactions or terminations of those liens that you need to get out of the way in order for you to gain priority. And then another common way to deal with this sort of situation where you have multiple secured lenders is through the use of subordination agreements. So let's talk about those in a little more detail. What are they? It's essentially nothing more than an agreement between creditors to determine priority in certain collateral. It can be used in real estate situations and in security interests covering chattel like crops and equipment and livestock and that sort of thing. It's an agreement between creditors. The debtor, the borrower, need not be a party to the agreement and typically isn't. It's just an agreement between the two creditors. They need not be recorded or filed to be effective. But generally, they have to be supported by some sort of consideration. The senior party that's giving up, that's like stepping aside or giving up its priority, needs to get something in return for subordinating its position. Yeah, but that need not necessarily be like a direct payment to the senior lender who's subordinating, but some form of benefit or consideration, like maybe the simple fact that by subordinating, I have now permitted my debtor the opportunity and the means to obtain financing elsewhere that's going to let him operate for another year and generate more cash flow and help service my own debt. That could be sufficient consideration. Subordination agreements need not be long, complicated documents. And I say that so that as kind of a warning, frankly. I mean, a subordination agreement could really arise from a simple couple of sentence exchange between a couple of creditors, as long as it's something that can be proved and show that they signed it or if they assented to it, it can be given the effect of a subordination agreement. Some common terms to think about if you're going to try to skin this cat through a subordination agreement. What you typically see in them is an acknowledgement of the existing security interests or mortgage liens that the two parties have, an agreement that one is going to have priority over the other with respect to certain collateral. A good subordination agreement will be very specific about the type of collateral that's covered by the subordination agreement, either describing it at least by categories like you see under the UCC, or maybe even particular items of collateral if it's going to be that specific. It should specify a time period so that it doesn't just go on indefinitely unless that's what you in fact intend to do. So in the situation of a crop lien subordination, you might typically see that it's effective for a year or that it's limited to, you know, the crops grown in 2017, and that's it. Typically, we'll have provisions about what happens if there's a borrower default, because keep in mind that under a subordination agreement arrangement, that secured lender is not releasing its lien. It's retaining its lien. It is simply agreeing that someone else who would not otherwise have priority is going to step ahead of them. So it creates a situation where you have two lenders sharing some common collateral. So the agreements, or at least a decent agreement, will then typically spell out what happens on a borrower's default, because you are sharing this collateral. And some terms might typically be that the two creditors will agree to give each other notice if either one of them declares a default under their respective loans, or to give notice if they commence any form of involuntary or voluntary collection action or liquidation action, you know, something that might result in the sale of the common collateral or other disposition of the common collateral. So, few pointers there on subordination agreements. So the first part of this kind of deals with what can happen by agreement and cooperation between the parties. The next part of this deals with what might happen involuntarily, starting with ag liens, and for that I'm going to turn it over to Dean Zimmerly.
All right, thanks, Jeff. Now, as Jeff mentioned, one of the ways that we can have, you know, financing, or how a farmer can have financing for the next crop year if you decline to extend as much financing, or if they don't, you know, if they're not looking to finance through you again, is to work with their input suppliers, their landlords, to figure out how to defer payments until there's a harvest. So Minnesota statute provides some protections for these types of people, people that are providing these inputs on credit to farmers, to make sure that at the end of the year, when there's a crop, that they end up getting paid. So where you can find these is Minnesota statute 514.964. This covers kind of your agricultural liens related to crops. There's also some ag liens related to livestock. That's a little bit beyond what we're talking about today, but just beware of those as well. So what kind of ag liens we have include landlord's liens, harvester's liens. These are people that are involved with picking crops, combining, hauling, and even storing crops after the fall. And then also crop production input liens, and these are your inputs, your fertilizers, seed, labor, that go into actually putting a crop in for the year. So the first type of ag lien that I want to talk about is the landlord lien. So the question kind of is, if you don't advance money to pay for rents for this year, for 2017, or if by agreement they just defer rents out till the next year, well, what can the landlord do with respect to the crops or anything like that, where you might have a security interest in? So 514.964 provides that a person leasing real property for agricultural production, your landlord, has a lien for unpaid rents on the crops produced on that real property. So this provides just simply that the landlord is going to have a lien on those crops. And the lien becomes effective when the crops become growing crops. So basically when it's too late for the landlord to rent to someone else, et cetera, when they're growing crops, the lien becomes effective. Now, the important part about this is that when it becomes effective, that means it's enforceable between the landlord and that farmer that's that's their tenant that's renting from them. So they can enforce that lien against that tenant without doing anything further as soon as the crops become growing crops. Whether they can enforce it against third parties, security interests, or security interest holders, that depends on whether or not they file the financing statement, whether they actually perfect. So this is really similar to your own situation where if you're extending credit to a borrower on a loan and they sign a security agreement, you have a right against that collateral covered by the security agreement the moment they sign it. You won't have a right as against third parties until you've gone ahead and filed your financing statement to perfect it. So it's the same situation with a landlord. So the landlord's lien is perfected by filing a financing statement within this time frame that's set out in the statute, which is 30 days after the crops become growing crops. So you're really looking at these typically would have to be filed, probably by the end of June, depending on when the crop goes in. So that's how they become perfected. So the next kind of question is, if they've got a landlord's lien and they have a perfected landlord's lien, how does that stack up? How does that impact your own security interest in that crop for this year? So the statute sets out that the perfected landlord's lien has priority over all competing security interests and agricultural liens in the crops and products or proceeds thereof. So it's pretty much a trump card. The landlord's lien gets priority over your own ag lien. This is different than your normal situation where the first party to file a financing statement typically has priority. Here, even if you've had a 10-year-long relationship and multiple security agreements and always continued your financing statements, a landlord could potentially get priority over you. The caveat there is that their lien is limited only to the crops grown on that particular land and only to the amount of the unpaid rent. So if that landlord is owed other money from prior years or other real estate or for other debts, that same borrower, this landlord lien doesn't extend to pay off those debts, and it doesn't transfer between different parcels of real property. This can create some problems, though, that even if it's limited in that sense, it creates some problems because the landlord can also file an effective financing statement, and this is where they give the financing statement that alerts grain buyers, elevators, and the like that they have that lien, and that in order to buy the grain from that farmer in the fall of the year, they need to be able to put that the landlord's name on the check and the borrower's name on the check. And the issue that arises, of course, is that the elevator doesn't know when a trailer full of grain comes in if it came from, the south quarter of Section 21 or the north quarter of Section 6. If they see that this landlord has a lien on corn from this borrower, they're going to end up with their names on the checks, and then that's going to be a dispute that needs to be fought out later if a dispute ends up coming up. So it does create some problems, but it is limited really only to those fields, those particular crops grown from those fields. The second type of statutory lien I want to talk about is crop production input liens. So this is where, for example, the borrower has gone to the co-op in town and purchased seed from them, or gone to a seed supplier and purchased seed, purchased fertilizer on credit, on open account, to be paid sometime in the future. And the question is, where do those suppliers stack up to your own security interest in the event that there's not enough money at the end of the year to pay everyone off, or if the crop production input supplier doesn't get paid for some reason. Same statute provides that supplier furnishing crop production inputs in the ordinary course of business has an agricultural lien for the unpaid retail cost of those inputs. So again, this creates that lien automatically by statute that's enforceable against that borrower. And the second question really is, well, what is all covered by these crop production inputs? So the definition of crop production input includes agricultural chemicals, seeds, petroleum products, the application of those, labor used, basically all inputs that are going into this new crop year. And some of these inputs are actually further defined. So agricultural chemicals include things like fertilizers and agricultural chemicals like pesticides, fertilizer material, plant amendments, plant fluids. All of these things fall within agricultural chemicals. And the fact that fertilizer is included, and you'll see this in the next slide or two, is pretty important because the fertilizer and the crop production input can actually attach kind of year over year, where inputs that are applied in November actually can attach to the next year's crop. It also includes here petroleum products. And those are fuels that are used in the production of agriculture. So your diesel fuel that might be supplied by the co-op, that can be a crop production input as well. So what is it attached to? The crop production input attaches to and basically the collateral of the crop production input lien is going to be the existing crops and land where the agricultural chemical was applied. And here's the important part about fertilizer. If there's not existing crops on the land when it's applied, so if crops are not planted, then it attaches to the next production crop within 16 months following the last date of application. So this is where your fall application of fertilizer gets carried over into the next year's crop. The crop production input also attached to the crops that come from whatever seed was furnished, and the crops produced from any petroleum product. So again, it's limited in the same sense as the landlord's lien, where it only attaches to basically what that supplier provided for the farmer. So now that the crop production input supplier has a lien, the question is, where does it stack up with respect to everyone else? So it's possible for the crop production input lien to actually gain priority over an existing security interest if you're not careful. How this works is that the input supplier sends a lien notification statement to you, the lender, that includes a number of things, including the address of you, the lender receiving it, the address of the supplier, the description of the inputs, the cost of it, etc. and the person receiving those inputs. So within 10 days of receiving that lien notification statement, the lender that receives it has to do one of two things. They either have to respond with a letter of commitment for part or all of the amount amount specified in that statement. They have to say, those inputs, we will agree to finance that for this year. Or the lender must respond with a refusal to provide that commitment. And they must do this within 10 days, or the perfected crop production input lien will have priority over that security interest in the same crops or their proceeds. So this is important that if you receive one of these crop production input liens, you either notify that supplier that, yes, we will extend that credit, or no, we don't want to extend that credit. It doesn't matter which, but if you don't do anything and you don't respond in time, that input supplier can have priority over you. So just a quick example of how this would work. Say that First Bank ends up with has a perfected security interest in all of the farmer's crops, includes crops grown in the future, after acquired property, etc. And then in 2017, this crop year, the co-op agrees to sell seed corn to the farmer on credit, and the co-op sends a lien notification statement to First Bank indicating we've sold $20,000 of seed to the farmer on credit, indicating that they're going to claim that agricultural lien. And this can end up with three outcomes. So the First Bank can respond by saying, yes, I'll agree to finance that $20,000. And if they do that, then the co-op actually doesn't get a lien at all. They end up simply getting paid by that lender. First Bank can respond by refusing to pay any amount and saying we're not going to finance that. And in that case, everyone's rights are pretty much unaffected. The co-op will still have their lien, but it will be junior to the lender's lien. And then finally, if First Bank doesn't respond, then the co-op, they'll have priority over the First Bank's security interest, assuming that the co-op files its financing statement to perfect its lien. So the important thing to note on that, it really is, if you end up receiving these lien notification statements, to respond to them one way or the other, just to make sure that you don't lose that priority. And I think that's really everything on the agricultural liens, the statutory liens, except we have maybe one clarification.
Well, actually, a question came in, and I thought this might be a time to try to field this. I'll take a whack at it, Dean, and then you can tell me what you think.
All right.
The question that's posed is, how do you perfect a landlord lien on crop like alfalfa that's not planted every year? I'll try. Yeah.
That's an interesting.
First of all, I don't know of a case that's addressed it. I'll tell you what my thought is, or what my analysis is here. As Dean mentioned, the statute talks about how the landlord lien becomes effective 30 days after the crops become growing crops. It doesn't say 30 days after they're planted. And the question uses the word planted. Crop like alfalfa that's not planted every year. And maybe we're getting a little esoteric here, but does alfalfa become a growing crop every year? Is it dormant over the winter? Honestly, I don't know. I think that would be the issue a court would face. Does alfalfa become a growing crop only once? Or does it die or become dormant and then grow again in the spring? I know a way to avoid the issue would be to refile. It would be for the landlord to refile each year. But honestly, I've never had a case or, that specifically addressed that, or know of a court decision that does. Do you guys, have you ever run into it, or have you heard anything?
I have not heard of that. I agree with your analysis that it would seem countercyclical to say once it when it becomes growing, it becomes growing in the spring, and I think it would be a very interesting scenario that a court would have to reach. But I think just common sense would say if you filed it, now, I mean, they haven't harvested any alfalfa, it may or may not be growing, but if you harvest it now, I think you'd have a very good argument.
So maybe avoid the interesting scenario by refiling each year. It kind of raises a related point, and that is to, sometimes your borrowers are landlords. So, in terms of your relationship with your borrower who is a landlord, do you have discussions with them about these sorts of things? What steps are they taking as a landlord to protect their right to get paid? Because if you've got a standard security agreement with them, a blanket security agreement, your borrower landlord's rights to enforce a lease, to collect rent, to get paid under a lease are collateral for your loan to that landlord. And so that would include these sorts of lien rights and so I don't know, it just occurs to me that if you've got borrower landlords, this is a subject to talk about with them as well. What are they doing to perfect their payment rights, which in turn are collateral for your loan to them? So, well, thanks for the question.
I do have one more question just came in. Can a third party, not a supplier, get an input lien by financing the crop for the farmer?
I think not. Well, sorry, Dean. Go ahead.
I agree with you, Jeff, that the answer would be probably not, because the way that the statute's written is that it's the supplier furnishing a crop production input, and then crop production input are these things that we talked about. Crop production input doesn't include financing to buy these other inputs. So I think the statute is limited to people that are actually providing those inputs, not providing funds for those inputs.
Actually providing the seed, the petroleum, the fertilizer.
Yes. Okay. So I think the next topic here is some issues related to bankruptcy, and with that, we'll let our resident bankruptcy expert, Mike Dove, handle that.
Thank you, Dean, and thanks to everyone for participating today in the webinar. Hopefully we'll have answered some questions for you. So, bankruptcy, always the word that scares people a little bit. Sometimes it should, and sometimes it maybe shouldn't. But a couple of the issues we're going to look at here today is Chapter 12 bankruptcy provides basically it's a farmer reorganization. Farmers can also file a Chapter 11 bankruptcy, and the primary time when an 11 is used over a 12 is when they don't qualify for a Chapter 12. The amount of debt, and the debt can be too large. To be a Chapter 12, a farmer in that, you have to have less than $4.1 million of debt. And 50% of your debt must arise from the farming operation, and 50% of your gross income must arise from the farming operation. So it's a three-part test. So anybody that has an aggregate debt over $4.1 million is not eligible to be a debtor under Chapter 12, and that's where you will see generally Chapter 11s filed for that reorganization purpose. The one issue that generally faces us as lenders in a bankruptcy reorganization is that they want to continue to operate. Now, obviously, if they were great operators, they wouldn't be in bankruptcy. So it has impacts on lenders and what they can and cannot do, along with being forced to do certain things that we'll talk about as we go through the remainder of the presentation. But generally, in a bankruptcy, the lender retains its security interest as of the date of the filing. So if you have a security interest in all the crops, livestock, machinery, and equipment on the date of the bankruptcy filing, you will retain your interest in those specific items of collateral. You will not retain it if they get some new crops absent some extenuating circumstances that we will discuss going forward. The priority remains the same as on the date of the filing. So, for example, if someone properly perfected their landlord's lien, as Dean talked about earlier, and you have a blanket which is now in a second lien position to that landlord, the filing of the bankruptcy does not disrupt that. So if you're in a first lien position, have a blanket, then you're going to be in that position as of the date of the filing of the bankruptcy, provided all of your loan documents, going back to what Jeff said, are properly signed, executed, and have the right names. Otherwise, if that's not the case, they can avoid liens by what's called a preference or sometimes a fraudulent conveyance. So loan documents are very, very key when you're into a bankruptcy. What happens is your after acquired clause basically becomes moot on the date of the filing of the bankruptcy. So where this comes into play more often than not is in the livestock. So if you have, let's say, a dairy cow that's sitting out there, Minnesota says that any milk produced after the date of the filing is a post-petition asset and not subject to your security interest. If you're financing hogs and the sows have not had the piglets yet and they haven't, given birth, those new piglets, again, generally are not subject to your after-acquired property clause. And also, generally for bankruptcy issues, the important topic is that you're prohibited from taking actions to collect against debt outside of the bankruptcy. It's called the automatic stay. We have talked about that at numerous times at our Ag Lending Conference, but it's just make sure that don't do something once you have knowledge of a bankruptcy, because the courts do not take that lightly, and you can actually get sanctioned significant amounts of money. So it's a very serious type of issue. So what happens when my borrower files bankruptcy and wants financing from a third party? As Dean and Jeff both have pretty much described, outside of a bankruptcy, the third party lender cannot safely lend against 2017 crop year because of the after acquired property clause in your security agreement, absent, as Jeff was mentioning, a subordination agreement. But inside of bankruptcy, the Bankruptcy Code allows a third party to avoid this result by saying, and the court can authorize the incurring of a debt secured by a lien on property that is not otherwise subject to a lien. So if someone filed Chapter 12 today and you, the lender, have 2016 crops sitting out there, but they want to get a new bank to come in or a new lender to come in and finance 2017, the court has the ability to put and give new lender a significant or a lien on the 2017 crop that will be ahead of anybody. So if we look at an example of the pre-petition lending package, First Bank has a prior protected security interest in all of the personal property, including crops. First Bank provided the operating loan in 2016, but said, no, we don't want to do it in 2017. And this is where we may see some issues coming up here in the next 2 to 3 weeks, as far as people who have not gotten their financing are going to be behind the 8 ball. Second Bank wants to lend farmer the 2017 crops and would, but for First Bank saying, no, you're not going to do anything with respect to my security interest as this First Bank lender. So then what happens, or could happen, is farmer's going to file bankruptcy and he's going to bring a motion to incur secured debt. So an example here is First Bank doesn't have a secured claim in the 2017 crops because they're not yet growing, okay? The court can grant the Second Bank's motion to get a lien on the crops and the insurance and all the other benefits that can do there, and therefore put them in an absolute first lien position. So the filing within itself allows the farmer to continue operations with a new lender, notwithstanding a prior security interest. You may ask, why would someone want to finance a person in bankruptcy? It's called DIP, debtor in possession financing. A couple of reasons. As we talked about, you're going to get a first lien on a lot of different items, number one. And number two, you can typically talk, because of the risk, you typically get a higher interest rate along those items, and it allows you under the bankruptcy, if you negotiate this properly, to have a significant amount of control and monitoring of your 2017 financing or 2017 crops. So that's kind of like what we call a prepackaged bankruptcy, where they come in with the financing already in place. They bring the motion, the farmer gets the financing for the year, and the second bank then has a priority lien on virtually everything. So what can happen if the bankruptcy trustee or the debtor do with my collateral? And this is a situation we see more often than not in a bankruptcy filing. So a lender's sitting out there and has grain in storage from 2016 or earlier and the proceeds. So now what can the debtor do? Well, the debtor can sell your crops with respect to taking that action, but in order for the debtor to do that, those crops are now, in the bankruptcy terminology, called cash collateral. So here, in this situation, the debtor could, as I said, file, has all types of corn, soybeans, other, fungible items that's your collateral. The debtor has the ability to use that cash collateral and use it for his farming operation. So a little questions about that. What is cash collateral? Well, it's either cash, so if he has $30,000 or $100,000 of grain proceeds sitting in your bank, that's cash, it's cash collateral, or other cash equivalents, which, as I said, means corn or soybeans that are sitting out there that can easily be converted into cash. Now, the rub for the 2016 lender here is that the trustee may not use this cash collateral unless the secured party consents. So you, as a bank, always have the ability to say, okay, I'll give you permission to use the corn and soybeans to plant your 2017 operation. Or you say, no, I don't want to do that. And the court authorizes, in other words, tells you that, no, the debtor does get to use your cash collateral because the debtor can provide you what's called adequate protection. Adequate protection is basically a fight to see, are you going to be in the same position as you would be as of the date of the filing of the bankruptcy petition. So what is adequate protection? The court can grant you an additional or replacement lien. So let's say the debtor has his 2016 crop sitting out there, wants to sell them and wants to use it to plant the 2017 crops. But, the debtor is going to offer you a replacement lien on your 2017 crops. But as we've talked here earlier, there's sometimes this year, these past couple of years, where there's a negative cash flow. So what is the real assurances that you are going to maintain the status quo over the use of this time period? This is the place where there's typically more arguments and discussions in before the court and with the debtor, because it's all going to be based on that cash flow. Does the farmer generate sufficient proceeds in 2017 to make sure that you, as the lender, are going to get back the same amount of money that's sitting there at the time you file bankruptcy? And again, this becomes a factual issue. It has an evidentiary issues as far as getting in. Surprisingly enough, that when a lot of farmers file, their cash flows increase significantly because their yields are going to go up 10 bushels an acre. They're going to get $3.85 for corn when the market price is $3.25. And yet,
it's a special corn.
It's a special corn, yeah. And you're going to have a lot of particulars to pay attention about because as we all know, in order to get a cash flow to work, there's got to be tweaks, and it's either going to be more income or less expenses, and you use that and compare that to the actual operations history. So the court can grant you a replacement lien. The court also has the ability to grant a lender, in this situation, another lien on unencumbered property. So, for example, I have been involved just recently, this is next page, I guess, where the farmer wants to use $100,000. The farmer has equity in certain real estate that no one has a mortgage on. So while in addition to getting a replacement lien in the 2017 crop, this lender in this particular situation also received another mortgage for $100,000 in unencumbered real estate that gives the lender some additional protection in the event the farmer actually ends up losing money and doesn't have sufficient corn or grain proceeds to secure that debt. Or the cash collateral that was used. The purpose of cash collateral and the replacement is to maintain their status quo. You're not necessarily going to be entitled to any more, but the debtor has the burden to show that you're going to get at least that amount of money that they used in their continuing farming, albeit losing operations. And again, that goes significantly to cash collateral and monitoring cash flows, comparing it to their Schedule Fs to see how much they've spent on fertilizer or, seed and chemicals in the past years, and how they're going to cut down to try to make it have a cash flow. So that's kind of it. Jeff says there's a question here.
Yeah, actually there are a couple of related questions here, Mike. I'll throw them out to you because they're basically Chapter 12 questions. First, what do you do with a farmer that says he's going to file? Threatens to file. I'm going to file Chapter 12, but he doesn't. You just press on with your collection efforts until he does?
Yeah, good question. I would continue to just move on and move forward with the collection efforts, presumably you went through farmer letter mediation, so you're now in ability to go forward, and he says, I'm going to file. Well, if he's not going to, that happens all the time. They say they're going to file, but I would continue to move forward. You are not violating any stay by having him say, I'm going to file bankruptcy. Your collection efforts can move forward until, in my opinion, you get a bankruptcy case number, which happens almost instantaneously nowadays when you electronically file a bankruptcy petition. It'll come back, it'll spit a number out. Once you have that information, then you have to stop. But prior to that, I would just keep on moving forward.
Another one. Suppose I'm the lender to this farmer. I have a lien in place that covers the feed that he has on hand. Livestock question. My security interest covers the feed on hand. He files Chapter 12. That feed gets fed to his livestock. Do I have any sort of priority in like the sale proceeds from those livestock because I had the prior lien on the feed that went into him post-filing?
That's a good question. That feed is also cash collateral. So in order for the debtor to feed any of your feed that's sitting out there, the silage or the hay bales, whatever happens to be, the debtor has to grant you some type of a replacement lien, whether it be in the new crops or the new calves that are going to come out or the new hogs or whatever's going to be there, but you do have the right to demand that for the value, if it's $100,000 worth of feed out there, you're entitled to receive $100,000 of proceeds through the liquidation or through the replacement of additional animals to cover you from that position.
How about depreciation? Another question. Specifically, how is a secured creditor protected against depreciation in the value of equipment or breeding livestock, let's say, over the course of a bankruptcy that might take them a year to get a plan confirmed, and then, it's another 3 years after that during the plan?
So the answer to that question is called adequate protection. Not cash collateral in this instance, but additional adequate protection. So let's say you have financed, and we'll just keep it simple, one tractor that's sitting out there, it's worth $50,000, it has a value, and the debt on there is $50,000. So there's no equity in that piece of equipment. If you called Jeff or I or Dean, we would say, okay, let's move and bring a motion for relief from the automatic stay since, we got to make sure we protect ourselves. So either in doing that or in discussing the situation with the debtor, we would negotiate what are called adequate protection payments. So if the tractor is going to depreciate, let's just say 10% over the next 9 months during the harvest or during the farming season, at some point they have to pay us that amount of money to keep us in the same position, that $5,000. Then you get back to negotiating when is the payment going to be done, how is it going to be financed. But you are entitled to adequate protection payments to, again, maintain your position and the value of your collateral the same as it was at the date of the filing of the bankruptcy.
Okay. All right. We had another question come in here. This relates back more to the crop side of things and statutory liens, and I think kind of goes to who's afforded protection under that statute. The scenario basically is, what if some third party purchases supplies, seed, inputs, that sort of thing, they buy them, they provide the supplies to the farmer who then uses them. Can that third party claim protection under the statute? And I'm going to sound like a lawyer and say, I think it depends. But here's what I think it would depend upon. Whether that third party really fits the definition of who's protected under the statute. And I think you get into the weeds a little bit, but a supplier under that statute is anybody who furnishes. So this question, it kind of sounds like the third party is furnishing, but the lien protects people who do that in the ordinary course of business, their business. So I don't think there's necessarily a black and white answer, but I think it would look at what was the nature of the transaction. Was this third party like in the regular business of buying supplies from one source and then selling / furnishing them to the farmer? Or was it just a dad who went out and bought seed corn this spring and, you know, gave it to his daughter and son-in-law to use? I think it could depend on those facts. But, you know, remember, even a person who is protected under that statute doesn't get priority unless they go through the notice, send the notice letter that Dean talked about. So.
Oh, and even then, only if the lender that receives that notice fails to respond.
Right, thank you. Yes, very important. So when you get a letter that says important legal notice, read it. Respond. It looks like our time is nearly up, and I don't see any other questions being posed right now. So with that, we will wrap it up. Again, the materials will be on the website for about a month or so. Feel free to consult them and pass them on to your colleagues. Thanks again for participating. Dean or Mike, do you have anything else?
Just that our next Ag Lending Conference will be on September 7th. It'll be at the same place at the New Ulm Event Center. Notices won't go out for another 2 to 3 months, but we encourage you to obviously show up. And as important, if you have any questions or topics that you would like to see discussed, shoot an email to either Jeff, myself, or Dean here, because we really want to try to make it as educational for you, the lenders, as possible. And if you're running across something that happens on a routine basis and you need to know the answer, we'd love to talk about it. So thank you again for your time. We appreciate everything taking your time out of your schedule to hear us ramble on for a bit today, and hopefully it was helpful. So thank you, and if you have any questions again, any follow-up questions, just let any of us know and we'll follow up with you. So thank you and have a good day.